The International Criminal Tribunal for the former Yugoslavia is now in session. L'audiëntie Tribunal Penal International pour l'ex-Yougoslavie est ouverte. Please be seated.
Okay, Mr. Registrar, good morning to you. Could you call the case, please?
Yes, Your Honor. Good morning, Your Honor. Good morning to everyone in and around the courtroom. This is case number IT 0588T, the prosecutor versus Popović et al. Thank you.
Okay, thank you. Good morning, everybody. For the record, all the accused are present. Prosecution composition is as it was last Friday at the end. Defense teams. Okay, everyone is present, so we can proceed. Mr. McCloskey, we had pointed to some issues last Friday, which you had to do some homework upon and come back to us.
Yes, good morning, Mr. President, Your Honors, everyone. And I have endeavored to do that, but I first wanted to ask Mr. President, Your Honors, I noticed that I had inadvertently left out a discussion of 4 exhibits that are specific to a response of the Kravica warehouse argument that the defense had made in Borovchin, and it should just take me a very few minutes to go over those just to clarify it. I think it'll help you to understand this and make more sense out of the defense argument. I also failed to mention our sentencing request, which I would just do very briefly and without any fanfare.
Okay with us.
We think we've got 15 minutes.
You still have about 20 minutes. You still have about 20 minutes anyway.
And this shouldn't take that long, Mr.
No,
President.
it's up to you. How long it takes, it's your problem. So.
Thank you. All right. Well, then we'll just get right to it. If we could go to Exhibit PIC 00065, and this is an exhibit that was marked by the Kravica survivor from the west side or the right side of the warehouse, as Borovchin, I believe, refers to it, PW 156. I may have said 157 as well before. It's PW 156. And this exhibit, you may recall, is the exhibit that shows where he came from. Now, this is, of course, he was using the winter shot, but that shows that he was walking from the right side of the picture across the front of the warehouse and then went in through that door that we see marked where the red goes into. And now we can go to the next one, which is PIC 00066.
I'm doing the broadcast these photos because I think that guy had protective measures, and there is his initials on the.
I think that's. I don't know if he put initials or his number. Hopefully, we had him just put his number, but.
And if it's not his signature, the previous one, the first one, Yeah, but there wasn't 156 next to it. The first one that we saw.
And this shot is where he's marked B and made little markings, which was his attempt on the screen to mark where the bus was. But he described that the bus was in front of the warehouse and that he walked between the warehouse and the bus, and which is, if you go back to your recollection of the bus parked right adjacent to the warehouse, it is our submission that that was the bus that he would have walked between the warehouse and the bus. So while these markings are a bit out in front, I think if you look at the testimony, it's clear that he is walking between the bus and the warehouse. And if you recall, the bus was in front of this little door that we showed that he walked into before. All right, now let's go to Exhibit P02103. And as you recall, Mr. Wes provided some very brief testimony that the witness had told him that he'd gone into a little guard room in the warehouse. And if you recall, his testimony was that he went into the big room and went over to the right side of the warehouse. And I'd ask you to infer from the evidence that after the shooting began, he moved over and went into this little room. It's in sanction if you're having a problem with it. And in fact, I think there's there is now that room, or that little door where all the light is streaming through. That is the door that the witness came in, and the door that the witness testified he came out of. And this little outline that you can see is what Mr. Ruiz was speaking of when he talked about the little guard room. And if we could go to the same picture, but I asked Ms. Stewart to make lines on it that I've asked her to make. It's not, no witness has made this. This is just something so to call your attention to it. You can clearly see in the right side wall in the photograph, in the top wall, the construction of what would be the wall and ceiling. What I really want to call your attention to is over on the left side. You'll see that there's similar marks of white that outline what we believe is the wall that will come out perpendicular to that door. So this little room does not include the doorway. You don't walk in from that doorway into the little room. When you walk in that doorway, this little room is to your left, in our view. And so the witness would have crawled into this room and stayed there and then left out through that door. Now, that's important because the defense claims that this room is incorporated into the front of this door, and that it is a separate room that would have held only a certain number of people. Well, I don't think that is a fair interpretation of the evidence. The fair interpretation of the evidence is this is a separate room that you enter into from its own door, not from this particular door that we see. And I'd like to go to Exhibit P04529. This is a sketch. You may remember it wasn't long ago, and when we were into a rebuttal mode of trying to show roughly how many people could fit in each side of the warehouse. And this was a very rough draft document that Tomas Boastik used to help determine the number of square meters in those rooms, and Dusan Yance we put it on through Dusan Yance to help him in his conclusions about how many square meters were in this room. There is no evidence in the record that this diagram has anything to do with the little guard room. It does not. There's no evidence about that. It's not meant to deal with the guard room at all. It's a very rough, not to scale diagram, so it should not be viewed as anything to do with that guard room. It has to do with the two big rooms and the basic square meter measurements. All right. And in addition to that, Mr. President, I will merely reiterate what we said in our trial brief, that there can be no other sentence for all of these accused than life imprisonment.
If you could show me the picture again, the previous one.
Yes, sir.
Previous one.
The one with Ms. Stewart's markings on it?
Yes. I cannot clearly see the trace on the left side. Okay. Its own room, own door, in your opinion, was inside the room itself?
That is the prosecution's position, and that's correct. And if we could go to the other photograph, and just the yellow markings sometimes blot out what I'm referring to. Now you can clearly see the line of white there next to the bright door, both the vertical and horizontal. Those are the outlines of both the ceiling and the wall as it came out perpendicular from the doorway. Yeah, that is the indication of where the wall used to be as it came out perpendicular and parallel to the back wall.
Thank you. This is page 101 of that exhibit. Thank you.
Okay, we'll get to the questions, which I will try to answer briefly, and of course I'm here for any further questions. The first one on my note was responding to the Guevara argument that Article 49 of the Geneva Conventions is the ruling article on this point, and that it applies only to civilians. Well, we agree that Article 49 of the 1949 Geneva Conventions applies to civilians only, but that is, of course, not where the discussion and the analysis stops. We can also see that Common Article 3 of those conventions refers to hors de combat and does not limit it to civilians. But most importantly, we look, as has the appellate chamber looked, to customary international law. And as we look at Merksic and Martic, that the appellate chamber has a long discussion on customary international law, citing the various authorities over the years that have stood for and expanded the original view beyond just civilians. I would draw your attention in Martic particularly to paragraphs 305, 306, 309, and 311, where they lay out some of that customary international law. And just for an example that we have not been held solely in this tribunal to Article 49, Article 49 has required that for deportations, they be deported from occupied territory. Well, that has never been a requirement in this tribunal. Not that it has to do with this case, but that's just an example of how this tribunal, through its Article 5, has expanded the scope of the Geneva Conventions from 1949. Okay. The next question I see is that in the Miletich brief, there was an allegation that we did not specifically refer in the indictment to Miletich's role in restricting the UNPROFOR resupply convoys, and where we did specifically refer to his role in restricting the humanitarian convoys. Well, I don't believe that is correct, because if you go to the indictment under paragraph 75, where we specifically describe some of General Miletich's actions, we note that Miletich, acting individually or in concert with other members of the joint criminal enterprise to forcibly transfer and deport the populations of Srebrenica and Žepa, and knowing that forcing the Muslims out of the enclaves was unlawful, committed acts in furtherance of the joint criminal enterprise, as described in paragraphs 50 to 54 of this indictment, and below. And then, under the heading, making life unbearable for the inhabitants of the enclave, we go on to say, under I, he drafted Directive 7, which was signed by President Karadzic on 8 March, and called for the VRS to, inter alia, and then we lay out the two foundational points of this case of forcible transfer and how it began. One, the policy to create an unbearable situation so life was impossible for the Muslims. And two, the issuing of permits to reduce and limit the logistical support for UNPROFOR and the supply and material resources to the Muslims. So there it is. Now, yes, it is first noted that he drafted that, but we're not just putting that down as merely the drafter. Of course, we are holding him and the others in the joint criminal enterprise for carrying that out. And there it is, spelled in black and white, reducing UNPROFOR. Now, the next II, we particularly point out and emphasize the part about the Muslim restriction. But that should not be viewed to suggest he's not responsible for all of Directive 7, and particularly the part where it says reducing the help to UNPROFOR. And in fact, as I'm sure you're aware, the whole thrust of our case is regarding UNPROFOR is not so much that UNPROFOR is a victim in this case, but it's their reducing the fuel and other supplies and the reinforcements to UNPROFOR that directly affects UNPROFOR's ability to look after and protect and do their duty regarding the Muslim population. So, as we focus on the Muslim population, that's of course the focus. But we also clearly point out UNPROFOR, and the reason that UNPROFOR is so important is not UNPROFOR on its own, but UNPROFOR as it relates to the Muslims. Now, it's not just the indictment that lays this out. We may not remember much of my opening statement back in the 21st of August 2006, but what I attempted to do in a very short opening statement, as you may recall, is point out the specific and important links of the accused to this case. And I went accused by accused by accused. And I want to read to you, when I got to the Miletich section, and I read one of the convoy documents where General Milicic had made some specific restrictions on the inspection of cargo and fuel tanks. And then I said this. Now, and for the record, this is on page 443, back on the 21st of August, 2006. Now, this shows that General Milicic is playing a very important role in this. Now, on its face, there is nothing criminal about this, but it does indicate to us the role he's playing. And he can say to the Zvornik Brigade, I demand a detailed. Now, is that an order from a commander? No. Is it a directive you have to follow? Yes. This is consistent with Mladic's overall order, Directive 7, and the other materials that we've seen establishing the policy. And you'll see, speaking of fuel, how fuel was restricted and strangled. So by the time Dutch Bat was there in July, when these events happened, they didn't have enough fuel to run their air conditioning or their electrical, and they couldn't go out in the vehicles. And this is all the main staff's doing through their corps, through their brigades, as it was done with General Milicic. Now, that's pretty clear. General Milicic is involved in the restriction against UNPROFOR, both in the indictment, right up front in the opening statement. An indictment can't possibly list all the ways in which people commit crimes. We did our best, you required us to do even better, and this indictment does a good job of it. Also, in the Milicic's brief, they make conclusion that regarding the location of Milicic and Milovanovic in 1995. Now, the exhibit that I would draw your attention to, and is cited by the defense, but does not very accurately, is PO 3163. And this is a little information report done right before Milovanovic, I believe right before he testified, where we went over with him this complete collection that we had of reports from the main staff to the president. And those reports came out in the name of Milicic or Milovanovic, and sometimes others signing ZA for them. And he went through all of those and noticed his name and noticed Milicic's name and others' name. And he went through, and from that document you can see the conclusions of that. And he testified that basically this represents the time that he would have been there or Milicic would have been standing in for him. It's not perfect. You may recall there was Ms. Favreau showed Mr. Butler, I think it was on the same day, one document that went out in Milovanovic's name, one went out in Milicic's name. As Milovanovic goes to a front and comes back, this is clearly not going to be absolutely 100% representative. But it does give you a good idea of the long periods of time that Milicic was standing in and some of the periods of time that Milovanovic came back. So just very roughly, we can see from this document that for most of January was signed off by Milicic. I counted this morning 9 days in February. That was Milicic. The rest of it was Milovanovic. 6 days in March, that was Milicic. Mostly the rest of March was Milovanovic. 7 days in April was Milicic. May, it was a rough split. And then from 31 May all the way to 4 September, it's all Militich. And also recall, when Militich comes back, he's not always in the HQ. Sometimes he was in Zvornik looking after, when Milovanovic comes back, he's not always in the headquarters. Sometimes he was in Zvornik looking after an operation in that area. And when he does come back, he's going to be briefed, and they're going to have to communicate very closely with each other. So, and this is engaging General Militich in the briefing as well. So when Milovanovic doesn't come, when he comes back, that doesn't disengage Militich. In fact, if General Militich was the chief of the Air Force Defense, perhaps he would have been slightly more disengaged. But he, as chief of the operations, he is not going anywhere. He's fully engaged in all this material. So there's no real lack of knowledge or action on Militich's part when Milovanovic comes back. Yes, he would not be standing in this informal way that we have described and that you're the experts on now when Milovanovic is back. But that doesn't fundamentally change the equation here. In fact, it shows they're both working together. All right. There was another question regarding your adjudicated facts decision and whether that shifted the burden of proof. And I gave you my recollections on that at the time that none of us felt that there was any obstacle put forward by the trial chamber for either side on these adjudicated facts, that they were an attempt, of course, to streamline the case. And we found the language which reflects just that, and it's from 27 September 2006, page 2253. And Mr. President, you said, starting at line 3, basically, the decision means first that in as far as those 250 odd adjudicated facts that we have agreed with you upon, the trial chamber is simply taking judicial notice of the fact that that fact was adjudicated by a previous trial chamber. We are not going any further than that. The fact that a previous trial chamber has adjudicated that on the 11th of July, 1995, the VRS entered into Srebrenica does not mean that the chapter begins there and finishes there, and that you are, neither of you nor the defense, are entitled to expand on that. There are some adjudicated facts that obviously go in favor of your case, and there are several adjudicated facts that go in favor of the defense. What we have stated there is what I have told you. And if you need to expand on that to make things clear, because ultimately it's we who will have to adjudicate not only on that fact, but all the facts that are pertinent. Of course, you will be able. I think that it more than clearly establishes you are not putting the adjudicated facts in the way of anybody. They are free to put on their case, and that, of course, is consistent with the entire way you've run this case. We don't see authoritarian moves to block anyone in 3 years, which I'm sure is very much appreciated. And the last note that I have had to do with Mr. Borovchinen's claim that we have not charged him with aiding and abetting. Specifically, I have not charged him for aiding and abetting in the failure to protect section. This can be answered very simply by going to the section on individual criminal responsibility. It's paragraph 88 of the indictment, where we say, pursuant to Article 7.1 of the Statute of the Tribunal, and we list everyone, including Borovchinen, are individually responsible for the crimes charged against them in this indictment. And each of them committed, planned, instigated, ordered, and otherwise aided and abetting in the planning, preparation, and execution of these charged crimes as set out in detail in this indictment. But then we go on and repeat ourselves in more particularity. And we speak especially regarding Mr. Borovchinen in paragraph 92. And we say, as a separate and independent basis of liability under 7.1, Lyubomir Borovchinen's presence at or near the Kravitsa warehouse execution site described in paragraphs 30.4 and 43A of this indictment, together with his failure to intercede in order to protect prisoners there, instigated, assisted, and aided abetted the physical perpetrators of the killings, in that his presence served as encouragement and incitement to the physical perpetrators of the Kravitsa executions, who continued to kill prisoners during and after Lyubomir Borovchinen's presence. But we go on to the second part of that. And B, constituted a willful failure to discharge his legal duty, resulting in liability under 7.1 as an omission, in that Lyubomir Borovchinen had custody and or control over 1,000 Muslim prisoners held in the Kravitsa warehouse on the afternoon and evening of 13 July. He had a legal duty to protect those prisoners from harm from his own troops and others, including at least one member of the Bratanats Brigade Red Berets. Despite his ability to do so, Lyubomir Borovchinen failed to protect all the prisoners within his control who were held at the Kravitsa warehouse. The beginning of that paragraph mentions aiding and abetting regarding both those two, his presence as an encouragement and incitement, and his failure in his duty to protect. And I would just add one brief comment about this idea of aiding and abetting. Aiding and abetting has been defined as knowing of the criminal event and substantially assisting in it, intending to provide substantial assistance in it. Now, when determining the intent of an individual that hasn't confessed or made admissions, this is precisely how a prosecutor or anyone, a trier of fact, determines intent, that the accused knows about a crime and that he was part of it. Where trial chambers draw the line between aiding and abetting and actual intent, it's very difficult to determine. It's up to the individual trial chamber. There's no clear jurisprudence on that. The sentencing between the two, aiding and the abetting and actual intention, has not been very different. If you look and see what Kirstich was sentenced to as an intentional participant and what Kirstich was sentenced to as an aider and abetter, I think one was 45, 46 years, the other was 35. So they're not viewed as particularly different because, well, obviously they're not. When you intentionally take part and provide a substantial assistance to a crime, you're a key member of it. And none of these are individual crimes. They're all working together. This idea that there's one central figure and all the rest are elves and you have to determine who's most responsible, well, that's a matter, in our view, of sentencing. And so when you look at the evidence of knowledge of the crime and substantial assistance to it, you should infer, in my view, that one intends the known consequences of one's acts. You can, in fact, find that one intends the natural and probable consequences of one's acts. When human beings act and they know that the likely consequences of their acts are a crime, a horrible crime such as murder, you may infer that they intended that. That's the way we humans are. I don't think we need to get, in this case, into the likely consequences, because when Mr. Borovchanin does not act, he knows that's going to result in deaths, whether by bleeding to death at the warehouse or further executions, both. So please consider those words as you consider this very difficult but yet crucial area for international law. We are this far in the tribunal and we still have not clearly defined what it is that there's a difference, though the case law clearly says that desire is not a requirement. We don't have to prove that they want this to happen. Many times people commit crimes and they don't want or desire to have done that, but they do it because they have to do it. It happens. So that was the last. I think it was clear that there was no, in the indictment, there was nothing in the indictment suggesting that Mr. Beara participated in the reburials, so he cannot be held responsible under the indictment for that. There may have been a witness that mentioned his name regarding the reburials, and I think that evidence is in the case. But there's nothing wrong with that, but we absolutely stand by what we had said and what Your Honor had said before. So I think I've got most of them, or if not all of them, and stand prepared to answer any more questions, or sit down.
I think you can sit down.
Thank you very much, Mr. President.
Yes, thank you very much, Mr. McCloskey. We can now start with the closing arguments of the Popović defense team.
Good morning, Your Honor.
Good morning. You've got 2 hours and a half, as you know.
Popović defense filed its final brief and elaborated within the limits set out by the trial chamber its position on the indictment, crime base, testimonies of the witnesses, expert findings, and exhibits. I stick to these arguments. The time allocated for the closing statement does not give me the opportunity to elaborate on all the arguments set out by the prosecution in its final brief. As a result, I'm going to restrict my closing statement to the part of the prosecution final brief addressing the responsibility of Vujadin Popović. The prosecution's assertion in paragraph 2320 of the final brief that Popović was reassigned to the Drina Corps as the chief of the Intelligence and Security Department in November 1992 is incorrect. It relies on the testimony of the witness Mikhailo Mitrović. This testimony was clearly misconstrued by the prosecution, as it did not mean that Popović became the head of the Intelligence and Security Department of the Drina Corps Command once he was reassigned there. Popović initially became an ordinary officer in this department and then was reassigned to the 2nd Romania Brigade, where he spent approximately 1 year and a half. Thereafter, he was sent on a course for security officers in Pančevo, and only after that was he assigned to the position of the chief of the security department of the Drina Corps Command in early 1995. The witness Vojnović supports this when he testified that he worked with Popović for a year or a year and a half when he was the security officer of the 2nd Romania Brigade. It is transcript page 23712, 21st July 2008. The document by the Drina Corps Command of 11 May 1994, it is 7D485, was signed by Lieutenant Colonel Ranko Kuljanin in the capacity of the Drina Corps Chief of the Intelligence and Security Department. Further supports it. The enumerated evidence clearly indicates that Popović was not chief of the Intelligence and Security Department before 1995. Also, the reorganization, or precisely separation, of the intelligence from the security organ took place in 1995, not 1993, as the prosecution final brief states. This is evident in the fact that the previously mentioned Drina Corps document read that in 1994 the intelligence and security departments were in the same organ. In the next paragraphs, the prosecution analyzes various rules and documents to prove the responsibility of Popović, both for prisoners of war and refugees, as well as his duty to coordinate with MUP. The prosecution's arguments and analysis of these subjects are incorrect. The submission on Popovic's responsibility for prisoners of war is based on two grounds. First of these grounds are the legal norms assigning to the military police the physical security of prisoners of war. The prosecution submits that Popović participated in the organization and implementation of the measures for the security support. The security support includes, among other things, the military police measures. One of the military police measures was the direct security of prisoners of war and the guidance and control of the movement of refugees. It's paragraph 2328 of prosecution final brief. Since Popović allegedly had a duty to control the military police units, both from the Corps Command and the subordinate brigades, he was responsible for both prisoners of war and refugees. Secondly, the prosecution asserts that the Corps security chief was responsible for prisoners of war because he proposed to his commander ways in which the military police would be used, was authorized to direct the commander of the military police units in accomplishing the tasks ordered by the unit commander, and had control of the military police units at the corps and brigade levels. The prosecution's assertions were founded on distorted facts and misinterpretation of relevant rules and documents. The first rule misconstrued by the prosecution is the rule of Corps. It's 7DP 412. According to paragraph 468 of the rule of Corps, security support includes 5 kinds of measures, one of which were counterintelligence measures and activities. These measures are within the exclusive competence of the security organs and at the level of the Drina Corps Command, of which Popović was solely responsible for. These are the measures provided by paragraph 6 of the rule of service of the security organs. It's P407, assigning the counterintelligence works to the security organs as protagonists. All other security measures, including military police measures, were in the exclusive competence of the unit commander. These are command and staff tasks stipulated by paragraph 7 of the rules of service of the security organs. In these tasks, the security organ participates, that is, the need for his participation or extent of such participation is determined exclusively by the commander on a case-by-case basis. In this sense, the participation of Popović in security support as the security organ is different from counterintelligence measures as such, cannot be taken for granted or assumed, but must be proven on a case-by-case basis. This means that the prosecution must prove not only that Popović was authorized to participate in military police measures relating to security support, but that he really participated in the military police measures relating to security support, but that he really participated in the organization and implementation of such measures, because such participation was not obligatory according to the rules. It means that the prosecution must prove that Popović participated in military police measures relating exactly to the prisoners of war and or refugees in the relevant period. For example, Popović could have participated in the organization and implementation of just one of the military police measures, say in direct security of the main staff commander, General Mladić, in the Operation Action Juda. It is P3033. However, this doesn't mean that he participated in all other military police measures, and in particular those related to prisoners of war and refugees. The prosecution did not prove that Popović was ordered by his commander to participate in military police measures related to prisoners of war or refugees in the period relevant for the indictment. Prosecution also used an incomplete quotation and misleading interpretation of Article 29 of the regulation regarding responsibility of Corps Command. It is 7DP 410. The prosecution quoted in paragraph 2324 of its final brief only the part of sentence that the security organ of the Corps is responsible, I quote, for organizing and implementing security measures and undertaking other specialized work in the field of security. Close quotation. However, the sentence continues as follows, quote, that is placed under its responsibility by special regulation, etc., end quotation. The omitted part of the sentence limits the responsibility of Popović to security measures placed under his responsibility by special regulations. The special regulations were incorporated in the rule of service of the security organs. These special sorry. These special regulations made him responsible for counterintelligence work, not for organizing and implementing the measures of the whole security support, including military police measures, and in particular, those regarding prisoners of war and refugees. Accordingly, he was only responsible for professional management and control of the military police, not for the control of all its activities and duties. Professional management of the military police...
I suggest you keep some water handy.
Yes.
Bye.
Thank you. Professional management of the military police was precisely defined by paragraph 14 of the Rules of Service of the Military Police and include the organization for education and training, inspection of such training, taking part in drafting and establishment of military police units, preparation of the relevant rules and regulation, and taking part in the control and assessment of the combat readiness of the military police units. The responsibility for the other four kinds security support is provided by Article 9 of the same regulation. According to Section 6 of this provision, the Corps Commander is in charge of managing security service, responsible for the security support of the command and subordinate units, and institution, and taking measures on the basis of the regulation and his responsibilities. Prosecution submission that Corps security organ had the duty to control the whole work of the military police units of the Corps Command and subordinate units is contrary to the principles of the military organization for VRS established in this case. The main principle in the organization of command is principle of the singleness of command. I refer to VUGA, transcript 4 July 2008, pages 316 to 334. It was the supreme principle, meaning that the commander of a military unit has an indivisible and exclusive right to command all subordinate units and bears responsibility for the condition, combat readiness, and use of the units, as well as for the proper execution of all tasks assigned to the unit. I refer to Kosovac. It is 16 January 2009, page 224. In fact, the command function places three main duties and obligations on the commander: to take a decision, to issue an order, and to control or monitor or follow up on what he has ordered. I refer to Forza. It's 20 June 2008, page 586, lines 3 to 10. The prosecution's interpretation of Article 29 and submission that Popović was responsible for the security support and the control of the military police would mean that the brigade commanders issued orders to their military police units, but could not control whether they carried out such orders properly or not, because the Corps security chief was authorized to control military police in all aspects of their work, including the execution of orders issued by the brigade commanders. Such an approach would be in contravention with the principle of the singleness of the command by practically excluding the military police units from the effective command of the brigade commander. Anyway, Item 9 restricts the professional management of the security organ as regards the control of the work of the military police just within the limits placed under the responsibility of the security organs by special regulation as provided by the first paragraph of Article 29. The absence of the duty of the Drina Corps security chief to control the whole work of the military police units of the Corps Command and subordinate units is endorsed by the fact that there was no regular daily reporting of these units to the security organ of the Drina Corps. For general and daily control of the activities of the military police, it was necessary for the subordinate units to submit regular reports. However, there is no evidence to support that the military police units from the brigades were under a duty to send such regular reports to the security organ of the Drina Corps. Neither is there evidence to support that they did so at all. They submitted daily reports to the commanders of their brigades, as did all other units. The brigade commanders did not also have any obligation to inform either their own security officer or the security organ from the Corps Command about the orders given to the military police unit of his brigade or about the daily activities of these units. Without such reports, the security organ of the Drina Corps would not be able to know anything about the activities of the military police on a daily basis. This proves that the security organ of the Drina Corps had no duty to control all the work of military police units, but at corps or brigade levels. Otherwise, the line of regular reporting would have been established between the military police units of the brigades and corps and the chief of the security of the Drina Corps Command. The special regulations contained in Rule of Service of the security organs, which provides two kinds of their duties. The first group is counterintelligence work, and the second, administrative and staff work. The counterintelligence work had to be performed by the security organ without any order from his commander. The practical impact of such a provision on this case is that the prosecution had no need to prove that such work in the Drina Corps Command was performed by Popović, since he was the only individual carrying out the work, was not authorized to transfer such duties to anyone else, and the commander of the Drina Corps was not authorized to give this kind of work to any other officer.
The council is kindly asked to slow down for the purposes of the interpretation. Thank you.
Mr. Jovanovic,
Sorry.
you are aware now of the
Yes.
remark by, okay, so please slow down.
Sorry.
Okay.
I apologize to interpreters. The second group of duties, which includes military police tasks, was to be carried out only upon the order or request of the unit commander. I refer to VUGA. It's transcript page 30 June 2008, transcript page 057 to 058. For this group of tasks, the commander of the unit was exclusively authorized to decide whether the security organ would be included in the decision-making process relating to ways of using the military police unit. I refer to paragraph 2324 of the prosecution final brief. This further means that the commander of the unit was not duty-bound to seek a proposal from his security organ on ways of using military police units, but only when he deemed it necessary. He was not bound to inform the security organ of what tasks and orders he issued to the commander of the military police unit. Again, VUGA, it is pages 058 to 062. In this sense, it was not obligatory that the commander of the unit assigns the task to its military police unit through the security organ, as stated in prosecution paragraph 2325. It is also incorrect to assert that the security organ always directed the commander of the military police unit in accomplishing the tasks issued by the commander of the unit. He did so only if the unit commander found it necessary. Otherwise, the unit commander assigned the task to the military police commander without any participation on the part of the security organ. In addition, the chief of security of the Corps is responsible to the Corps commander for the activity of the military police unit in the Corps command, pursuant to paragraph 23 of rules, only when such activity stems from the task issued upon his proposal. Otherwise, he cannot assume responsibility for the tasks issued by the Corps commander to the military police commander without his knowledge. This is quite logical, as the security organ could propose the use of the military police only within the scope of his activities, which relates to counterintelligence work. All other use of military police, like the physical security of persons and features, could be proposed by the commander of the military police, who is the best trained and qualified for such tasks. I referred to expert report of VUGA, paragraph 290. Of course, the commander of the unit is authorized to assign any task and issue order to the military police unit without asking or even contrary to the proposals made either by the security organ or military police commander. In short, it cannot be taken as the rule that the security organ effectively participated in the organization and implementation of measures other than that of counterintelligence. According to the rule of service of security organs, paragraph 7e, the security organs participate also in, I quote, in operations that precede the initiation of criminal proceeding and criminal proceedings themselves, etc. It is, again, expert report of VUGA. It is 1175. 1175, paragraph 244. These duties are among the command and staff duties for which command organs are responsible and in which the security organ participate. It means that commander determines the scope of such activity, who will do that, military police or security organ, or both of them, when and whether the report will be sent directly to the prosecution or through the higher ranking officer, and whether such information will be sent at all. In this light, the military prosecution guidelines the prosecution indicates in its final brief does not replace the legal obligations and relationship in the command of the VRS provided by rule of service of the security organs and the law or military courts. Namely, the prosecution quote the obligation of Popović to receive reports about crimes and the report of any information up the chain of command. There is no evidence that Popović received any report or that he failed to report the information about crimes up the chain of the command. Because of that, Popović could not be responsible, as the prosecution states in paragraph 2409. In addition, the prosecution refers to some documents indicating that the chief of security of the Corps had a duty for the control of the military police units both in the Corps and subordinate brigades. The work plan of the General Corps for December 1994, it is 5D 989, tasked the Chief of Security with the control of the work of the military police units from the Corps Command and the subordinate units. However, the authors of the plan knew what kind of control over military police the security organs were authorized to perform. This document was intended for officers who knew very well the scope of their competence. As such, it was not necessary to write down in this particular document the various rules and regulations determining the nature, scope, and limits of the security organs' control over the military police. This plan did not exclude either corps commander or brigade commander from the control of their military police units, meaning that the control of security organ was restricted to the professional managing. The prosecution also misinterpreted 3 documents sent by security organ of the Drina Corps Command as evidence of Popović's competence concerning prisoners of war and his authority over the military police. The first was the instruction regarding the handling of prisoners of war, dated 15 April 1995. It is P196. In fact, this was the instruction of the security administration of the main staff concerning the security aspects of the handling of prisoners of war. It was observed that after exchange, prisoners of war became significant sources of highly sensitive military information about VRS for the enemy's intelligence. This was because before their exchange, they were kept near the front line or military objects with full insight into the deployment of VRS forces and units, their arms, and other data. The instructions alerted the commands from the battalion level upwards to determine places behind the front line where captured members of the enemy's army were to be kept, and warned that such, I quote, "a place must not be in the area of the command post, nor in the area of communication centers, artillery, weapons, or significant elements of logistic support," end of quotation. Accordingly, this instruction does not demonstrate the responsibility of security organ for prisoners of war, but the counterintelligence measures which had to be applied by the command to deter the intelligence activities of enemy forces and counterintelligence protection of material, technical equipment, zones, areas, and features of particular importance. These were the duties for which the security organs were protagonists as provided in paragraph 6A and C of the Rules of Service of Security Organs. It's P407. The parts quoted by the prosecution are, in fact, measures preventing prisoners of war from observing VRS units deployed in the vicinity, their arms, and other features relevant for the defense of Republika Srpska. In addition, the text of this instruction clearly indicates that Popović literally conveyed the instruction of the main staff security administration and therefore could not indicate his responsibility for prisoners of war. Basically, this was a clear example of the professional management defined by paragraph 14 of the Rules of Service of the Military Police. This paragraph includes, among other things, the education, training, and preparation of the military police members, preparation of the rules and regulation related to the military police. This instruction is the elaborated regulation on how to handle prisoners of war and keep them as far as possible from sensitive military information. Popović was bound to forward any instruction received from the superior security organ to the subordinate units, and this document just demonstrates that he did so. In addition, this document clearly demonstrates the competence of the unit commands for prisoners of war. This is indicated in paragraph 2, which reads, I quote, all commands from battalion level upwards are to determine places behind the front line at which captured members of the enemy army are to be kept. End quotation. They further advise what kind of risk should be avoided from a counterintelligence point of view. The second document the prosecution refers to is dated 7 February 1995. It's P3032. This document was sent by the security organ of the Drina Corps Command to brigade commands. This was again based on a request made by the Main Staff Security Administration seeking information about the management of the military police in subordinate units, their level of training, mobilization, logistics support, security and tasks. The document properly reflects the limits of the competence of the security organs over the military police. It also reflects the fact that the Chief of Security of the Drina Corps Command sought information necessary for professional management of brigade military police units from the brigade commands, not directly from the military police units of the brigades. If Popović had overall control over the work the military police units of the Corps Command, the subordinate units, he would have asked for such information directly and not through the brigade commands. The prosecution also misrepresented document 3D 436, which was the instruction sent to the chiefs of security and intelligence of the 5th Military Police Battalion of the command of the Drina Corps at subordinate brigades regarding the work of the military police checkpoints. The prosecution found, notably, that Popović assigned to the chiefs of security and military police commands in subordinate units responsibility for the implementation of the instructions. This is contained in reference 5074 of the last evidence. However, the document literally conveys the instruction of the commander of the main staff of the VRS, General Mladić, who pointed out, it is paragraph E, on the last page, just above the signature of General Mladić, that, I quote, assistant for security intelligence duties of the VRS main staff, corps commanders and their subordinate organs and units of military police are responsible to me, meaning General Mladić, for due implementation and acting upon this instruction. The sentence added by Popović was that chiefs of security in the units and commanders of the military police units are responsible to this department for the implementation of this instruction. This could only mean that the assignment of responsibility, which the prosecution wrote about, derives from the specific order of the corps commander to make responsible for the implementation of this instruction the security organs and military police commanders of the subordinate units.
Could Mr. Jivanovic kindly slow down when reading? We'd be very grateful. Thank you.
Again, you're being reminded by the interpreters that you're going too fast. If you could kindly slow down. I have the same feeling as well. So, in fact, I was thinking precisely of that before I heard the intervention.
Okay, I repeat my last sentence. This could only mean that assignment of responsibility, which the prosecution wrote about, derives from the specific order of the corps commander to make responsible for the implementation of this instruction the security organs and military police commanders of the subordinate units through security organ of the Drina Corps. In general, the military police commanders were responsible for their work either directly to its commander or through the security organs. In this particular case, the corps commander was made personally responsible to General Mladic for implementation of this particular instruction, decided to make them the subordinate units and security organs responsible for the implementation of this instruction through the security organ of the Corps. However, it doesn't mean that the Corps commander made either the security organs or military police commanders from the subordinate units responsible for all their work through security organ of the Corps. It actually indicates that this was the case only whenever he decided so, and this was stressed in document sent to subordinate units. The prosecution also misinterpreted the order dated 30 August 1995 concerning the disarming of UNPROFOR. It is 7 DP 978. This order was issued upon the order of the main staff of the security administration and was not sent to the military police unit or security organs of the subordinate brigades, but to the commands of the brigades. This meant that Popović intended to stress to the brigade commands the importance of the task because he was not able to issue any order to the brigade commanders. In fact, it was the request to the commanders to they issue requested order to their subordinates. The prosecution further misrepresented the role of Popović in the assignment of the tasks to the military police. He did not assign all tasks to the military police unit approved by his commander, but only those assigned upon his proposal within his purview, or if he was asked by his commander to give some professional advice based on the counterintelligence information and available only to him. Even then, his commander could issue the order to the commander of the military police unit directly without his involvement. For all other tasks, the commander of the unit issued the order directly to military police commanders and not through Popović. I'll go to another topic. So,
would like to break now?
Yes,
Okay.
please.
For the record, can I draw your attention to page 17 of the transcript, lines 21 to 22? The transcript, page 17, lines 21 to 22, it reads, but for prisoners of war and refugees. I take it should read both the prisoners of war and refugees. Do you find?
Just to
From line 20, it reads like, in the next paragraph, the prosecution analyzes.
Analysis various rules and documents to prove the responsibility. Both for prisoners of war and refugees. Sorry. Thank you, Your Honor.
Thank you. We'll have a 25-minute break. Thank you.
All rise for your evaluation.